My name is attorney Howard Ankin, and I've been practicing workers' compensation on behalf of petitioners for the past 26 plus years. Topic today is the 8D1 differential. In 2011, we had a law change which dramatically changed 8D1 claims. An 8D1 case is where somebody cannot go back to their former employer, and now there's a question about what they could earn today. So accordingly, let's say somebody was earning $12 an hour previously, and now they can only earn $9 an hour today. Under 8D1, they get 2/3 the differential, or $2 an hour, until they're age 67, or for 7 more years of compensation, whichever is greater. The old law, or if you have a case that goes before the 2011 law changes, stated that you got an 8D1 differential for life. The difference between age 67 or the 7 years next to a lifetime of 8D1 is a totally different compensation plan and was good for respondents when the law changed. In terms of an 8D1 differential, if you have an injured worker who is looking like he is not able to go back to work, there is typically a mental component to that for the injured worker that they need to realize that they cannot go back to their former occupation. It is usually good to have a conversation or a future roadmap about what the law looks like and where the claim is going. A lot of times people feel like they just want to get the case over with and move on, and they need to realize that the protections of the Workers' Compensation Act are there for them. Basically, once they get to maximum medical improvement, it is usually a good idea to have an in-office appointment in a conference room or office setting with the injured worker to explain the 8D1 differential. At that time, it used to be 25 years ago that a doctor may say in his opinion that somebody could not go back to their former employment. It is usually best that the injured worker has a functional capacity exam showing that they can't go back to their former job to solidify that they're not able to go back to their job. If that functional capacity exam shows that there was not full effort given by the injured worker, I would recommend that that functional capacity exam be performed again before the vocational process starts. With this, the injured worker should be counseled that they need to keep a logbook. The logbook is nothing special. It can be kept in any type of diary or piece of paper that the injured worker wants to keep. They should write down the names of the employers that they applied for a job with, the address, the telephone number, the date, and who they spoke with at the particular employer. 25 years ago, the age of the computer was not as prevalent as it is today, and most people were able to go apply in person. Today, many people are turned away from applying for a job in person, or if they do apply for a job in person, it needs to be done on a computer locally, or they'll be given some type of sheet that shows, or paper showing how they could apply by website from somewhere else. I think it's important for the injured worker to keep by date what they've done on a day-by-day basis, showing how they have applied to work. So even if they just put in their logbook that they had to go to the library that day in order to get their online time to apply by computer, that's something that they should do. Under law, the injured worker needs to start out looking for work by themselves and see if that looking for work is beneficial to them. If they find that they're not able to get work on their own, then a vocational counselor can be assigned to them. Typically, if the respondent agrees and there's no other disputes in the case, the respondent will provide a voc counselor. However, that voc counselor sometimes could be a little bit for the benefit of the respondent. There needs to be consideration given to whether that vocational counselor should be picked by the petitioner and they should use their own, or if it's okay to go with the respondent's assigned vocational counselor. This day and age, vocational counselors are charging between $2,500 and $3,500, and that may be a consideration for any case. If the vocational counselor is picked by agreement, then it could go down that way. If there's an argument as to who the vocational counselor should be, then there needs to be a petition brought forth before the arbitrator or the commission to decide who the vocational counselor will be. Ultimately, it's the petitioner who gets to pick his vocational counselor under law. Once the petitioner starts looking for work, I like to stress to the petitioner that they need to have a strong logbook, especially in a good economy like we have now, to show that to even show that they are not able to find work. I feel without a strong logbook in a good economy, how it is today, it is going to be hard for the commission to believe that someone cannot find work without a strong logbook or without strong cooperation with a vocational counselor. Accordingly, when they go through where they go through their meetings, keeping up with the vocational counselor, explaining what they've done, cooperating with going to appointments or meetings, that should all be done. At the close of when the injured worker finds work, in all other matters involving an average weekly wage, we look at the date of the accident going back 1 year to compute the average weekly wage. However, for an 8D1 case, we don't just take the average weekly wage or the hourly rate at the time the injured worker was injured, but let's say it took 2 or 3 years for the injured worker to find work. We take what the injured worker would have been earning at the time that the 8D1 claim is set. So accordingly, if you have a union petitioner, it may be easier under logbook to determine what that average weekly wage is. Other times, you may have to find a close comparison coworker that was working at that time to determine as a witness what the future average weekly wage is. Then you would take what the new job that the injured worker found, and then that would set the new average weekly wage next to what the average weekly wage was. If the injured worker would have kept working, 2/3 of that differential is the 8D1 rate. With that, then, you can look to try to lump sum by agreement between the parties what somebody could get based on how long their life may be based on government rate. Or if you were a respondent that had this capability, you might be able to determine for that particular worker looking at their medical records, how long they may be able to live. 25 years ago, typically we might have used interest factors at 5, 6, 7% to lump sum the 8D1. Today, with there being interest rates at 1 or 2%, that's really the interest factor that we may use. Also, before the law change, we may have taken the lump sum of an 8D1 based on somebody's life expectancy, that we would have only maybe taken 60, 70% of what the 8D1 differential was. Today, with that being capped at age 67 or 7%, I'm not really seeing people taking like a 60, 70% interest factor rate. Maybe there could be some rate for the petitioner getting a lump sum, but definitely not that aggressive. To learn more about the benefits of joining our ISBA Workers' Compensation Law section, please visit the ISBA website. Or again, my name is Attorney Howard Ankin, and I can be reached at 312-600-0000 if you have any questions about an 8D1 differential, the law, or how to prove up the claim.